Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam, the official podcast of the American Bar Association's section of Antitrust Law. I'm Matt Reynolds, and the title of today's episode is Are You In or Are You Out? Using economics to identify and quantify potential class members. As experienced class action litigators will tell you, getting a proposed class certified and keeping that class together through settlement or trial is no simple task. First, there are the four familiar requirements of Rule 23A of the Federal Rules of Civil Procedure: numerosity, commonality, typicality, and adequacy. And then there are the requirements of Rule 23B. In most antitrust cases, that's predominance of common questions and the superiority of class treatment of the claims. But especially in the antitrust context, the requirements don't stop with the plain text of Rule 23. Antitrust plaintiff classes need to show that they have not only good old-fashioned Article 3 standing to bring their claims, but also antitrust standing. In other words, that class members suffered an antitrust injury and are the proper parties to litigate over that injury. And class counsel also needs to show that the class they are proposing is ascertainable. In other words, that if the class is certified, class members and the court will have a mechanism for figuring out who is in the class and who is not. Now, each of these concepts could easily be the subject of its own podcast. So today, we're going to be focusing on the first and last requirements that I just mentioned: numerosity and ascertainability. Joining me to guide today's conversation is my co-host, Alicia Downey. Hi, Alicia.
Hi, Matt.
Can you go ahead and introduce our featured guest for today?
I'd love to. Dr. Tram Nguyen earned her Ph.D. and M.A. in economics from Stanford University. She's a managing principal at Edgeworth Economics, where she specializes in quantitative economic analysis and modeling in labor and employment, industrial organization, and firm management matters. She has supported clients on issues related to the economics of class certification for both direct and indirect purchaser classes, and in estimating antitrust damages in a broad range of industries, including agricultural products, railroads, chemicals, pharmaceuticals, and consumer products. Welcome to our Curious Amalgam, Tram.
Thank you, Matt. Thank you, Alicia.
Let's kick off the conversation. First question. Sometimes the easiest way to talk about an abstract concept, particularly where economic analysis is concerned, is by using a case study. Is there a particular case or industry that we can use for our discussion today?
Yeah, in fact, I do. So one particular industry that comes to mind is the pharmaceutical industry, not just because I often work on this, but I think it's a very important one where we can draw a lot of examples. And a type of case that often arises in this industry is a pay-for-delay case, and we can elaborate on what it means later.
Oh, we've had plenty of episodes about pay-for-delay settlements and antitrust in the pharmaceutical space. But why, when we're talking about class actions and the elements of ascertainability and numerosity, what makes a pharma case like that a good example?
So pharmaceutical industry is quite fascinating in the sense that the distribution chain is very complex and it involves multiple layers. So before a prescription drug gets to the hand of the end consumers like us, it has to go through multiple intermediaries. And there are often many players in this industry that interact, contract, and negotiate with each other. At the end of the day, it means that there are the layers that affect pricing of prescription drugs, which makes it very hard to understand or to figure out what the end payers actually pay. And on top of all of this, the demand for prescription drug is also not driven by the end consumer only. We all have health insurance, and the way insurance structure is very different. Our health insurance also affects our decisions, and sometimes doctor preferences also have to be taken into account. So all of these creates the issues of differently situated plaintiffs or plaintiff groups in these consumer class. And there are a lot of individualized issues that arise when we look at whether a class action should be moving forward or not.
It sounds like class actions in the pharmaceutical context have many more layers of complexity than some of the ones that I worked on in years past, where it was, simple consumer products type situations. I guess, as I mentioned before, we want to talk about two of the different requirements for class actions. And the first, and I think most would consider to be the easier of the two, is this idea of numerosity. And Tram, if you could just give our listeners, especially our young listeners who may be relatively new to class action practice or to antitrust practice, give them a sense of what's involved in the numerosity analysis.
Numerosity is, in a simple way, it just means how many class members are in the class. Do we have enough class members to bring forward a class? In pharmaceutical industry, numerosity is often an issue with direct purchaser class. So you can think of the wholesalers in this case who buy prescription drugs from the manufacturers and distribute them to pharmacies and retailers before we get to go and fill our prescription, right? There are these are big corporates, these are companies that you might have heard of. One of the big one is McKesson, for example. But there are also other regionals, local distributors, and wholesalers. So together they make up the group of direct purchasers of pharmaceuticals. Numerosity comes into place when usually we see there are between 40, 50, around that number of wholesalers in the direct purchaser class. Now, it's not really a hard and fast rule. We've seen the courts have taken into account other factors that might affect whether there should be a direct purchaser class, not just based on the size, but sometimes it's based on the geographic locations of these wholesalers and distributors. If there are wholesalers that are very large and they might be differently situated from all the other regional or local ones. Numerosity becomes a challenge often due to market consolidations and corporate affiliations of these entities. For example, a large wholesaler like AmerisourceBergen recently acquired H.D. Smith, which is another wholesaler. So now they are under one entity and together they account for a large market share. So this consolidation means that at first glance, the number of class members in a direct purchaser class might look like there's a lot of them. But after you account for all of these corporate affiliations and acquisitions and mergers, the actual number will shrink. So then we started with a big number, and then we might be going down to a threshold that's closer to 40, 50. That leads to an issue of if there are very large wholesalers like the big three, they might also have very different financial incentives. And then the court might be asking the question of whether it's feasible that these guys can just bring in their own lawsuit and have individual lawsuit instead of joining the class.
So I suppose the issue of numerosity also can be impacted by whether or not a court decides that there might be a role for subclasses to play. For those listeners who aren't familiar with this, it can sometimes be the case in class actions that you start with one large monolithic class and the court decides after considering the case that actually it's a group of subclasses that should be certified. So some members of the original proposed class will end up in one subclass, others will end up in another. It sounds like, especially in this direct purchaser context here, you could have a situation where there are enough subclasses that each of those subclasses no longer fulfills the sort of numerosity test that courts usually apply. What can happen if that's the case? Is there an alternative if a court decides, you know what, there's not enough direct purchasers to certify a direct purchaser class? What are the other alternatives that the court can look to?
Recently, we've seen that the courts sometimes look to joinder as another option instead of a class action. So joinder is when there are individual plaintiffs and they can together bring a lawsuit together without forming a class. So this usually happens when the number of class members is small enough that joinder becomes more practical. But it's also particularly true when class members have incentive and ability to work together. We can imagine a negative aspect of joinder is it can be quite complex and administratively complicated. But what's unique about the pharmaceutical industry is there's a lot of entities that are affiliated, they're under the same parent ownership. So there's already the incentive for these subsidiaries to work together. And when there's a lot of acquisitions and mergers that occur in recent years, it creates more of this structure so that there's more and more incentive for these class members to work together under joinder rather than in a class action.
And to make things even more complex, in some of the multi-district litigations that I've been involved in, you have a combination where you might have a direct purchaser class, an indirect purchaser class, and then potentially dozens of direct action plaintiffs who have been joined, but who are pursuing their own complaints and theoretically pursuing their own individual cases, all within the context of that single multi-district litigation. Well, I wanted to turn our discussion now. We've talked a bit about numerosity, and I want to talk now about the other element that we wanted to focus on today, and that is ascertainability. Maybe we could start by getting a sense of how ascertainability fits into this structure that we just described.
Right. So ascertainability is less of an issue for direct purchasers. Ascertainability means, can we identify all the class members in the class? Is there a mechanism to do so? So for direct purchasers, as we said, these are somewhat larger, more well-known corporates, and there are many, but not way too many of them that we cannot identify all of them in the data. And they often purchase pharmaceuticals directly from the manufacturers. The transaction is transparent, and you can trace who bought what at what price. It becomes more often issues for end payers, like you said. There's the direct purchaser class, and then often there's an indirect purchaser class or end purchaser class. It becomes more of a problem to identify who the end purchasers are in the data for indirect purchaser class plaintiffs. And especially in a pay-for-delay case, briefly, pay-for-delay happens when there's an agreement between the brand manufacturer and the generic manufacturers to delay the entry of a generic drug. And that means that the end consumers like us do not have the choice to purchase the lower cost generic drug, and we have to fill the prescription with the brand name drug, which is at a higher cost and allegedly suffer an injury from the difference between the price. So ascertainability comes into light when a person goes to the pharmacy and fill their prescription. Like if I go to CVS and I fill my prescription, I would expect CVS would have all of the information about my insurance, how much I owe them as a copay, how much my insurance is responsible for this transaction. On the surface, I can know which day I fill my prescription, how many pills I'm getting, what I'm paying. But in the background, CVS also knows who's paying for the rest of my prescription. Is it my employer, Edgeworth, or is it an insurance company that Edgeworth is contracting with that's covering this prescription? All of that information is not always visible, and it's not always well recorded in some database, and that leads us to the ascertainability issue.
Yeah, no, this is an interesting situation, as you say, especially in the pharmaceutical industry, because you have more than one end payer for literally the same purchase and the same product for the same consumer. There might be two or even potentially even more than two people who had a part of the end payments for that product at the bottom of the chain. That's not even to mention the other intermediate steps above them that you mentioned before, between even a direct purchaser and that end payer consumer. I think it's probably worth mentioning for the benefit of our younger viewers or those with less experience in the antitrust world, the distinction between direct purchase claims and indirect purchase claims. Under federal law, indirect purchasers cannot maintain antitrust claims. But there's a whole patchwork of state antitrust laws and state consumer protection laws that do allow indirect purchasers, like consumers like you and me, to bring claims under state antitrust laws or under these consumer protection laws. And so typically you will see in these large class actions, if there's an indirect purchaser class, often they will be suing under the laws of sometimes 36 different states. And that makes for some very complex briefing and some very, very lengthy decisions when it comes to certifying those classes. We talked a little bit about the pay-for-delay cases as examples of this. Are there other instances that you've seen where this ascertainability issue comes up as well, outside of pay-for-delay specifically?
Yes, another type of, outside of pay-for-delay in pharmaceutical, we also see product hop, or there's price fixing allegations. And ascertainability comes into play in a similar way as pay for delay, but with different nuances. So for example, with the product hop issues, we don't always observe what the end consumers, like individual consumers like us, or the third-party payers who are our employers or insurance companies, would prefer in the but-for world if the original product was still there, right? In product hopping, the pharmaceutical manufacturers switch the product to a different formulations or form. So we don't always observe the alternative, what the end consumers would do. And in those cases, it becomes a much bigger issue to ascertain who would be in the class who would actually suffer from the alleged conduct, because we don't actually observe the but-for. We don't know if consumers would prefer to stay with the same product or they would still switch to the new formulation. So that's another type of case that often arise in pharmaceutical industry that we see. But at the end of the day, ascertainability is really about the lack of information that transactional claims data that occur at the pharmacies does not always capture. In an ideal world, we should be able to see who pays for what product at what price. In practice, we don't always observe net price paid by the end payers, and we don't always observe who the end payers are in these data set.
So let's jump then to the actual topic of this episode, which is the economic analysis and your role as the economist in ascertaining the number or the identity of class members in a particular case. You mentioned that in a perfect world, you would get clean, complete sales data from, say, the point of purchase for indirect purchasers, and I suppose for direct purchasers as well. What is the ideal data set, and what exactly would you do with it as an economist?
Let me go back to the example of me going to CVS and fill my prescription. So in that example, at the point of sale, an ideal data should capture the end consumer like myself, how much is my out-of-pocket cost, what drug I buy, how many pills I buy. And then in the background, the data should also capture my employer, who is Edgeworth, the insurance company that Edgeworth is working with, for example, Blue Cross Blue Shield. And then the important piece of information is between Edgeworth and Blue Cross Blue Shield, which one of them is actually covering the rest of my prescription. And then, of course, how much they're paying CVS for that prescription. So that's the ideal data I would like to have. Now, in practice, we don't always have that. Some data set that's available from third-party data might only capture either Edgeworth or Blue Cross Blue Shield. And the data does not always tell us if Edgeworth is the ultimate end payer or Blue Cross Blue Shield is paying on behalf of Edgeworth. And this is because there's usually two types of health plans that are called fully insured or self-insured health plans. They are really two sides of the coin, if you want to think of it that way. A fully insured health plan means that Edgeworth is paying a fixed premium per month per member to Blue Cross Blue Shield, and then Blue Cross Blue Shield will cover the rest of the cost. So Edgeworth is fully insured. The company should know exactly the cost of health insurance to themselves. So in that case, Blue Cross Blue Shield is the end payer for my prescription. And ideally, the data should tell me that. The flip side of the coin is if Edgeworth is a self-insured health plan, then that means Edgeworth is only hiring Blue Cross Blue Shield to be the third-party claim administrator for that prescription. Edgeworth is covering the entire cost. And the data should specify that Edgeworth is the end payer, not Blue Cross Blue Shield. That's the ideal world. In reality, sometimes we see in one data set, we might see Edgeworth name or we might see Blue Cross Blue Shield name. We don't really know who's self-funded, who's fully funded, and we don't really know who the end payer is. So that creates a problem for economic analysis, because we really need to know the net price, and for ascertainability, we need to identify all the end payers in the class.
So you have a data set with gaps, perhaps ambiguous information, perhaps even inaccurate information, depending on who was keeping what records. How do you deal with it? Do you just throw your hands up and say, well, we can't ascertain the class members? Is there some magic that you can perform using econometrics to get to an answer?
Yeah, so as economists, we don't often opine on whether there's enough data to ascertain the class. We can measure how much we can know about the payments in the class. With this kind of data set, we usually should be able to sort of calculate the net price paid by end payers in the class. It's more of the question of who they are that we don't know. And what often happens is there's not really a threshold of 70-80% of the data that we cannot use. It's more of a question of the data comes from different sources, and then you might imagine one third-party data might not have any of this information at all. So 100% of that data, we don't really know who the end payer is. But then some of the data set from a bigger insurance company that might have more information, and then that data is enough that we can use and identify the end payers, how much they pay, and study overcharge, all of that. So it's more of the question of what kind of data is available, which section of the market it applies to. Do we have enough information to say something about the class as a whole or not?
And, it sounds like there might even be an additional issue in that the insurers, for example, probably can share based on their data what they know you should have paid as the consumer, as the insured, what portion you would be responsible for. But that's not necessarily the same as getting actual proof that you did in fact pay that amount or didn't pay some other amount. You had a coupon, you had some other arrangement, or for whatever reason, the point of purchase seller sold it at a different price. So it must be interesting too, dealing with getting data suggesting what should have been paid versus data which shows what actually was paid and trying to reconcile those.
Right. That's actually a very good point, Matt. It's often the case that for end consumers like ourselves, if you use a coupon or if you have a flat copay, for example, if you're paying the same for a brand or a generic drug, these information are also not captured in the data. So as end consumer, we know whether we use a coupon and that brings down the actual amount we pay the pharmacy, but CVS might still record you pay $20 copay for that prescription. So that part of information is also lacking in the data. And that's another point of ascertainability for the end consumers that I didn't mention before. For end consumer, it's also sometimes not obvious to trace back what is the actual price you pay, even though the data record who you are, right? They usually have your name and information, but the accurate measurement of your net price is sometimes missing in this kind of data set.
So in cases like this, is there a battle of the experts with one side offering an opinion that, because of missing data or inaccurate data, there's simply too much uncertainty. We cannot ascertain the class members. There can be no certification, which is, I know, the legal conclusion, versus the other expert who would say, well, we have enough data. We know we can ascertain enough of a class. Is that how the opposition usually sets up?
In my opinion, it's usually more important that the type of class members that should be excluded or included in the class can be identified versus what is the percentage of the class member can be ascertained. So, for example, some class definitions often excludes fully insured health plans or state and government health plans. And it's not a question of how many of these we can exclude it from the class definitions based on the data. It's often the question of can we even do that at all, given the state of the data. And it's often the case that these data, for example, wouldn't tell us who the fully funded plans are or which ones fall under the state and government health plans, so that we can even start measuring what is the percentage of the data we can tell from these health plans.
Another interesting dynamic, I think, in this context, of course, and this is true in lots of different class actions, as Alicia asked, sometimes there can be a battle of the experts, but what happens where you have both sides wanting to reach a settlement and get a settlement class certified? Both sides are aligned. Have you had any experiences in your own work where early on in the case there was an epic battle against ascertainability and then a couple of the defendants decided to settle and then all of a sudden everyone's on the same side trying to say, no, it's enough. We have enough data. We can figure this out.
To be honest, Matt, I have not come across that. I think it's usually the opposite, that the battle of the experts are mostly about measuring the overcharge, studying whether the same methodology can be applied across the board to all class members. And then at some point, we come to ascertainability point, where even if we can go past all of the econometrics and economic calculations, who does it apply to? Who are the class members? That's usually the question that comes up at the end. And that's, I think I've seen in recent cases, often an issues that trouble the court.
Well, Tram, thank you so much for this great discussion about these aspects of class action practice and economic analysis. As you may know, part of our show is getting to know you not only as a professional, but also as a person. And so we like to ask a couple of questions to each of our guests. The first one, which I'll ask you, is tell us something interesting about yourself that your own coworkers might not know about you.
So I think my coworkers really know that I really like traveling to beach destinations, but I think what they don't really know is I'm actually a beach snob. So I've been on a hunt to find the perfect beach, and I've been to all sort of black sand beach, white sand beach, green sand beach in Hawaii. And I think what I realized over time is actually there's no perfect beach. I like them all, and every time I go to a new beach, I'm quite amazed by how nice they are. I always thought the perfect one has to be white sand and calm and in a tropical setting, but I come to appreciate all sort of different sceneries that I see.
Do you have a top 3 beaches for all of us out there listening?
I do. So one recently that I've been to is Trunk Bay in St. John, U.S. Virgin Islands. And then the second runner-up is Grace Bay in Turks and Caicos. And surprisingly, the third place, I think I'll give it to an unnamed beach that I spent an hour hiking down the mountain somewhere in Costa Rica. It was completely empty when I got there. It was amazing. It's just the jungle and the beach.
Well, that's the great thing about this podcast. You tune in for economic analysis and you get travel recommendations. And with that, we're going to transition to a game that we call the Curious Hat.
And now it's time for the Curious Hat.
Tram, the rules of the game could not be more simple. I have selected a random surprise question from the virtual Curious Hat. So here's what we're curious about today. And indeed, it ties very nicely with your love of travel to beaches all over the world. When you do go traveling, what are some of your favorite tips for packing?
Funny you ask. I would say I pack very light. I am in the camp of one bag traveling. So I usually, if it's under 2 weeks, I bring one backpack. I found a perfect bag that I can fit everything in. And I would say packing light is always the advice.
Wow, 2-week trip with a single backpack. I consider myself a light packer too, but I do not think that I could live out of a backpack for 2 weeks. So good for you.
I love it.
Well, thanks so much for this interesting conversation today, Tram, and thanks to you, our listeners, for tuning in to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.